behalf of the Board of Student Advisors, welcome to the 75th Ames Final Argument. It's our pleasure to have so many past winners tonight, contestants, and of course their families and friends. We have a distinguished panel this evening, and we ask that there be no flashes during the argument and no moving around unnecessarily, please. It's also a privilege tonight to introduce the Dean of the Harvard Law School, Dean Vorenberg, to introduce the panelists.
My role is a brief and happy one. First, I have the pleasure of welcoming you all, students, faculty, staff, alumni, and friends of the school, to this very special Ames Final Argument. Tonight's program marks the 75th anniversary of the Ames Moot Court Competition, named for James Barr Ames, the Dean of the Law School, from 1895 to 1910, over there. He is also the man in whose honor the courtroom has been named. Among you tonight are 25 former winners of the Ames Final Argument from the New England area, representing more than 800 alumni who have participated in the finals. Justice Blackmun, by the way, was a member of one of the Ames Finals team in 1932. I wish to extend the school's special thanks to the members of the board who take such care in organizing the Ames competition, and to the students who are arguing tonight, as well as their colleagues who worked so hard on the briefs. And if they were in the room, I would certainly thank the judges for joining us. You're all invited to a reception in the John Chipman Gray Room in Pound right after the argument. I hope you all have a fine evening. Thank you.
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business with the Honorable Supreme Court of the United States shall draw near and give their attention, for the court shall now be sitting. God save the United States and this honorable court.
I take it, Mr. Bailiff, that the pages are off duty tonight because we almost sat on the floor, and usually they hold our chairs, and when you get over 95, you need all the assistance that one can get. I take it there are no admissions to the bar today. We have to have admissions because this supplies the United States Treasury, and there was a day when it, as you know, when it all went into the court coffers, but admissions are falling off, and we have to do something about it. Justice Kearse, do you have any opinions to announce?
Relating to anything in particular?
For those assigned opinions that haven't been forthcoming, that were argued last June, I've been waiting for them. Posner, do you have any?
I've been away doing other things, Mr. Justice.
So I understand. Well, we'll proceed to the calendar. It's number 86116 is the first case for oral argument. Forrest Phillips, individually and as executor of the estate of Iris Phillips, petitioners against the Higginson Corporation, Inc. and S.P. Kaiser, Inc. respondents. It comes to us from the Court of Appeals for the Ames Circuit. And with counsel ready, we'll proceed. My predecessor as Chief Justice always said, you may proceed, Mr. Smith, whenever you are ready. I've been waiting for someone to say, well, I'm not at all ready. But Mr. Engelmayer?
Good evening, and may it please the court. My name is Paul Engelmayer. Along with my co-counsel, Christopher Grisanti, I represent Forrest Phillips, the petitioner in this case. The issue before this court tonight is whether parties seeking to bring tort claims against cigarette manufacturers have been categorically prevented from having their day in court. I will address the federal preemption issue in this case, and I would like to focus this court's attention tonight on two broad points. The first is that there is simply no evidence that Congress, in passing the Cigarette Labeling Act, intended to eliminate common law claims and thereby leave smokers without any judicial remedies. The second is that the purposes Congress articulated when it passed the Cigarette Labeling Act will be frustrated, not advanced, by a finding of preemption here. Mr. Grisanti will then argue that the Ames Court of Appeals below was wrong to forbid Mr. Phillips from sharing any of the information that he has gained through discovery in this case. The facts of this case are as follows. Mr. Phillips' wife, Iris, died 3 years ago of lung cancer. She had smoked 2 packs of cigarettes a day since 1942, when she was 11. And
She started that very day smoking 2 packs a day?
According to the record, yes, Your Honor, as alleged by
She
petitioner.
didn't have an initial illness or anything behind the barn when she first started? 2 packs the very first day?
Believe it or not, Your Honor, that is what she has alleged. She alleges that she has been addicted to cigarettes since 1950, when she was 19.
How do you define addiction?
Your Honor, petitioner has not defined addiction in his complaint. However, we are alleging that we believe that addiction means an inability to stop smoking.
That's a little different from drug addiction, isn't it, where one has to go back to the drugs in increased doses. I take it you're using it just as the inability to stop.
That is correct, Your Honor.
So it's really a habit rather than an addiction.
Pardon me?
It's more a habit than an addiction.
No, Your Honor. The issue here is whether Mrs. Phillips was indeed able to stop smoking, and that's relevant for these reasons. The respondents have argued that Mrs. Phillips, having been sent a message by Congress, was able to stop smoking after 1956, and that she chose to continue smoking. We believe, Your Honors, that Iris Phillips was unable to stop smoking after 1950. And for purposes of the legal decision on a summary judgment motion, this court must accept that fact as alleged. Your Honors, that leads me directly into my first point. That is that Congress did not intend to eliminate the common law claims of cigarette smokers, be they addicts or others, in 1965 when it passed the Cigarette Labeling Act. Your Honor, that act says nothing about eliminating common law remedies. It says nothing about closing off access to the judiciary, and it says nothing about common law claims at all. Its preamble delineates quite closely the field in which Congress expected to operate. Here's what the preamble says. It says,
I'm not sure why you care about the statute, because you say from 1950 on she couldn't stop smoking. So it can't be your theory that the problem with the cigarette company's conduct was that they didn't warn her with sufficient clarity of the dangers of smoking.
that is correct, Your Honor. However, the Court of Appeals below has argued that Mrs. Phillips lacked the will to stop smoking after 1956. It has, in effect, ignored the factual allegation in Mr. Phillips's complaint. That is why the addiction continues to be relevant in this case.
But I mean, you're abandoning, aren't you, your failure to warn theory of liability?
Not at all, Your Honor.
Because no matter how strong the warning, if she couldn't stop, she couldn't stop. So they could have said, anyone who touches this package will get cancer, and it wouldn't have made any difference.
That is not, Your Honor, the Court of Appeals below tried to eliminate only the failure to warn causes of action. Mrs. Phillips, anything that is not based on failure to warn under the Court of Appeals theory would persist. Your Honor, the Cigarette Labeling Act...
Let me interpose a question
Yes, Your
here. In that those causes of action would survive, is it appropriate for the Court of Appeals to have accepted jurisdiction to hear the appeal at this time?
Absolutely, Your Honor.
Well, why is its ruling a controlling one that will dispose of the case?
I'm not sure I understand why there would be a problem with the Court of Appeals ruling as a matter of law.
Well, we're talking about appellate jurisdiction, and I gather from the record that the district court granted certification under Section 1292B.
That's correct.
And although it's not clear from the record, I gather we are to assume that the Court of Appeals granted leave to appeal. Now, why was that appropriate if the case is going to continue on other theories?
Your Honor, I am unable to account for the behavior of the Court of Appeals except to suggest that this is a very pressing issue. It relates to 50 other cases around the country. It may well be that the Court of Appeals sought to get this issue resolved so as to clarify a decision that is likely to have ramifications in far more than its particular circuit.
Well, it may have ramifications for 50 other cases, but it doesn't seem that it's going to dispose of this one. Perhaps we should dismiss as having improvidently granted cert, or set aside the decision below of the Court of Appeals as having improvidently granted leave to appeal.
Well, Your Honor, with all due respect, we would urge that you not dismiss this case. For these reasons, Your Honor. The issue of smoking and whether longtime smokers should have a cause of action is a critical one. Congress...
A cause of action for what?
A cause of action for, in this case, for products liability, for negligence, for deceptive advertising, and for failure to warn.
Well, I have a problem with the failure to warn, because it seems to me your basic allegation is that no warning would have any effect on her, and therefore couldn't affect
That is correct, Your Honor, but
so how is it a failure to warn case?
It is a failure to warn case, Your Honor, because it may well be that if this case is ultimately returned to a trial court, if Mr. Phillips is given his day in court, that the addiction fact will not be proven, and yet Mr. Phillips will...
Well, let me ask my question a little differently. As I understand the federal statute, it relates to warnings. But if she is, maybe it's not addiction in a technical sense, but if she can't stop smoking, it seems that the warning is not a terribly important one way or the other. And therefore, in what sense is this question of law, however important in the large it might be, controlling of this litigation, dispositive of this litigation?
Your Honor, it is controlling because Mr. Phillips's allegation that his wife was addicted to smoking is one that may or may not be proven true in the trial court. This court should continue to hear this case, Your Honors, because in case that fact is not proven, Mr. Phillips will then be pursuing claims...
So this controlling question might easily disappear if the case were tried.
Your Honor, if in fact she is proven to be addicted, then the issue of failure to warn, we would allege, is irrelevant. There was no message...
Didn't the Court of Appeals jump the gun in deciding to review the case, to review a difficult issue that might not be dispositive in this litigation, might easily disappear?
Your Honor, we would urge that this court continue to hear this case because the subject matter is so important. This court does have the ability to hear issues of its own motion, and we would hope that it would do so in this case. Your Honors, just to pursue the issue of Congress's intentions, which is the key issue in this case.
Before you get over there, let me speak of my discomfiture about failure to warn. Are you taking the position that she needed to be warned?
Your Honor, we are taking the position that the state of Ames has taken in its causes of action. That is that when one puts a product out on the market, one owes certain common law.
Well, has anyone ever believed that cigarette smoking is good for one?
No, Your Honor, but,
100 years ago, when I was in law school, whatever it was, Lucky Strike or Old Gold or Chesterfields or any of the others, everyone spoke of them as coffin nails. Coffin nails.
Your Honor, Mr. Phillips only seeks his day in court to prove that very point, that cigarette smoking may in fact be hazardous to one's health, and that Mrs. Phillips may not have received the warnings necessary to fill her in on the information she needed to know to make an informed choice.
Let's pursue that for a second. Do you think it's open to you under the statute to argue to the jury that this warning that the federal government requires is no good, and that this jury should send a clear signal to Congress by awarding heavy damages, showing that it just doesn't believe that a warning like this is adequate to shake up a person like Mrs. Phillips, who is habituated to this and requires some overwhelmingly powerful warning. Is that argument open under the statute?
The argument is certainly open, Your Honor, that juries could find that...
I mean, you could, in front of the jury, disparage the federal warning and say that is inadequate. Congress made a mistake. It should be a much stronger warning. And I want you, the jurors, by bringing in a verdict for my client, to send a message to Washington that that warning has to be beefed up.
Your Honor, the issue, Your Honor, that would be an adequate warning, although I would phrase it a different way. And the issue would be whether or not the warnings provided by Kaiser and Higginson were adequate, not whether Congress, in announcing a statute that had a fundamentally different purpose from calibrating a duty to warn to that of traditional tort law, was erroneous. Your Honors, Congress's purpose when it included the terms adequate warning was not to calibrate its warning to that of tort law. I call your attention to the quotes in our brief that demonstrate from congressmen all over the country that they did not expect that they believed that tort suits would continue.
Some of them said that this meant there'd be an assumption of risk defense.
Your Honor, that is absolutely true. Many congressmen did believe that once in court, many cigarette plaintiffs would face a very stiff assumption of the risk defense. That's not an issue here. The issue is rather whether Forrest Phillips can have his day in court at all. He may well face some stiff evidentiary barriers, and particularly if he is unable to prove the fact of addiction, which he has alleged. But that's not the issue in this case. Your Honors, Congress twice returned to the Act, in 1969 and in 1984, and its behavior then, as we demonstrate in our brief, shows that it felt that tort claims, however foreboding an obstacle or proof might be for an individual plaintiff, were totally consistent with the Act. Congress was well aware that tort claims were continuing in 1969 and in 1984, yet it did nothing. If Congress considered those claims to be inconsistent with the Act, its will was being frustrated. It did nothing. Finally, Your Honor,
Did anyone ever want a judgment in one of these cigarette cancer cases?
No, Your Honor, they did not. But Congress was well aware that the suits were continuing. And the issue tonight, as for Congress, was not a matter of whether or not a cigarette case should be won or lost in the particular case, but whether it should be allowed to be pressed at all. This court has never held that a federal act has preempted all state remedies when doing so would leave open no avenues of judicial recourse or compensation.
Well, suppose that's what Congress intended.
Your Honor,
Preemption's a matter of congressional intent. Suppose Congress intended that there be no tort actions.
Then we would not be here tonight, Your Honor. Petitioner concedes that. But there is no express preemption provision that deals with common law claims in the Act. Quite the contrary. It excludes common law. It says nothing about common law claims, and in fact refers rather to mandatory warnings imposed by state agencies or by state legislatures. It also bars
by
warnings
political subdivisions.
by political subdivisions.
Perhaps we should consider the courts, the state courts, political subdivisions.
Your Honor, I think this court
Many judges are elected.
This court has long been loath to consider itself a political body. I would urge it to continue.
No, I didn't mean we were. But there's no separation of powers in many states.
That is correct, Your Honor. But in this case, Congress is the numerous statements on the floor of Congress from uncontradicted by respondents in their brief demonstrate that that Congress fully expected tort suits to continue. And that should bear on the interpretation of the term state in Section 1334. And there's a good policy reason for that. What Congress was concerned about, Your Honors, was conflicting mandatory labels on cigarette packs. One can well imagine the chaos that having mandatory labels would cause. Tort liability raises...
Suppose it became settled in the state of Ames that in order to have an effective assumption of risk defense, a cigarette company has to have, in addition to the federal label, which is required, another more shocking label with pictures of people dying of lung cancer and so on. And that's the only safe haven that is available under the common law of Ames. And if you don't have that, why, you have to pay enormous punitive damages. Why wouldn't that be a mandatory label?
Your Honor, that would be like an injunction in demanding a very specific label, and that would clearly be preempted under Section 1334A. That prohibits any statements from being required. And clearly, the graphic statement that you have offered would qualify as a statement every bit as much as New York saying smoking can stunt growth.
So there is some preemptive effect on common law adjudication.
Absolutely.
Potentially.
1334A would clearly rule out a specific performance or any sort of injunction. That's not the issue here. Here, Your Honor, respondents have been unable to prove, for example, that they could satisfy their common law duty to warn by taking other steps. For example, putting labels inside packets or warning people in other ways. Moreover, Your Honor,
Would you carry this argument, let's forget about the federal act for a minute because you're speaking of common law arguments. Would you carry this into the liquor industry also, where I've looked, of course, at many labels, but I haven't seen any warning labels on liquor bottles?
Your Honor, if Congress chose to do so, it certainly could. But Congress repealed prohibition, it repealed the Volstead Act, and Congress's intent is what should control here. Here are the statements in Congress, here the Congress's acquiescence in ongoing tort suits, and here this Court's tradition of not inferring an intent to eliminate last remaining remedies should control here.
But as an experienced trial lawyer in this field generally, you would not hesitate today to bring an action for chronic drunkenness because of the consumption of alcohol. Why not?
Your Honor, there is nothing that Congress has done that has preempted such claims. I think, as a matter of fact, there might be quite a good bit of difficulty proving that there was no assumption of the risk in light of what's known about alcohol. Your Honor, let me turn very quickly to a final point. The respondents have sought to describe the Congress as having created a delicate balance between the tobacco industry and the public interest. Your Honor, every element of that balance was explicitly contained in the Act. Common law remedies were not. It would disrupt that balance to suddenly include a big factor on one side of the occasion, the tobacco industry side. And I would like to call your attention to the many things that Congress allowed states to do that would have the effect of harming the tobacco industry. For example, imposing stiff cigarette taxes or imposing their police powers. Common law remedies were not mentioned in the Act, and nor were those things. This Court should not infer from Congress's silence that somehow, despite the absence of presence of quotes in the congressional record, that Congress intended to preempt and it meant to.
Thank you, Mr. Engelmayer. We've stolen some of your time by our questions, but that is routine in this Court. And we'll now hear from Mr. Grisanti.
Good evening. May it please the Court. My name is Christopher Grisanti, and I also represent the petitioner Forrest Phillips. Tonight, I wish to focus this Court's attention on one broad point. This Court's decision in Seattle Times v. Reinhardt does not require a trial court to ignore the First Amendment. The Ames Court of Appeals, however, advocates that kind of constitutional boycott. This error should be reversed, and the District Court's decision to deny a protective order should stand for two reasons. First, there's ample evidence within the Seattle Times opinion itself that the First Amendment should not be ignored in protective order analysis. And second, Judge Rice, the trial court judge in this case, did exactly what he was required to do under Seattle Times. Turning to the Seattle Times opinion.
Didn't he interpret Seattle Times to forbid him to enter a protective order? Didn't he
Your
say
Honor,
that it would be improper? Did he purport to exercise any discretion?
Yes, Your Honor, he did exercise discretion. He did what Seattle Times commanded of him, which was to weigh the competing needs and interests of both sides in the protective order analysis. And he felt that while the respondents' interests were legitimate, they were overridden when he took into consideration, as he's required to do under Seattle Times, the First Amendment as well as other factors. Turning to the Seattle Times opinion, far from banishing the First Amendment from the protective order landscape, Seattle Times established a First Amendment test right up front.
Well, up front, what about the last sentence? As I recall the last sentence, the Court said that if there's a finding of good cause, and if the order is limited to pretrial discovery, and if no information is suppressed that was obtained from sources other than discovery, a protective order doesn't offend the First Amendment.
You've touched on the key of the opinion, Your Honor. First of all, from that sentence, you cannot infer that the First Amendment should be completely prohibited from any part in the analysis like the Court of Appeals does. Second, there's a footnote to that very sentence. In that footnote, this court went through a number of other First Amendment concerns which weighed on that case. There were access to courts, petition, association, and even in Seattle Times case, religious freedom. In that particular case, they advocated the granting of a protective order. However, when you take those kind of interests into consideration here, you find that denial of the protective order...
But you're confining the court's decisions to its facts, the facts of that case.
No, you're not. No, I'm not, Your Honor. For example, let's take the court's opinion as a whole. The court, first of all, as I mentioned, establishes a test. It requires that any protective order must further a substantial government interest in order to justify the suppression on speech. And second, that court emphasizes both discretion and balance on the part of the trial court. It's the trial court, in its discretion, which must determine when a substantial government interest is at stake. In other words, it's the trial court that determines when a protective order would violate the First Amendment. Then, Seattle Times go on to say, and I quote, "Trial court must fairly weigh the competing needs and interests of all the parties affected by discovery." Now, when the trial court has done this, as Judge Rice did, it includes the First Amendment within that balance. To exclude the First Amendment would be to go against those cases in which the same First Amendment test has been used. In the prison context, in the schools context, in the military context, in many contexts where this court has analyzed the extent of First Amendment rights within government institutions, it has never prohibited the First Amendment from becoming part of the trial court's consideration. An additional point within the Seattle Times opinion, which indicates that they meant the First Amendment to be considered, was, as I pointed out just a few minutes ago, the First Amendment considerations that it itself takes into consideration.
What weight should we give this oral agreement not to disclose?
The oral agreement not to disclose, Your Honor, has not, as of this point, been broken. And the trial court had evidence of the oral agreement, and it's the trial court that should take weight of it, and not this court. The trial court
You say you haven't broken it yet, but you're planning to break it.
No, Your Honor, the trial court has taken such an agreement into consideration.
What do you mean under consideration? You made an agreement. Are you going to stick to your agreement or break your agreement?
Your Honor, we find that as we see more and more documents, there is a need to, unfortunately, break our agreement.
Well, break your agreement. Well, but haven't you waived any First Amendment claim? You made an agreement. You wouldn't disclose the material. You're going back on your agreement. You're adults. You waived it. Why should there be any issue of the First Amendment in the case?
With all due respect, Your Honor, even adults can take account of changing facts and must change their arguments accordingly. The trial court heard the exact arguments you're making and found that the interest in dissemination must overcome. Now, agreed that there is an agreement, and the respondents are quite free to assert the confidentiality of various documents to prevent dissemination if they feel that a particular document would injure their commercial well-being.
What does that mean exactly? Does that mean you're willing to have a protective order cover specific documents, but not to have a wholesale protective order?
Your Honor, as we showed in our brief, if they can prove both a clear harm from the revelation and that economic injury is serious, then they have a right to protect certain narrow classes of documents. However, the sweeping protective order that is urged on the court tonight would do far more than that, and the trial judge understood that.
Have you negotiated with respect to categories that you're willing to have covered by the protective order?
Respondents bring up in their brief, and we can agree with respondents on this point, that the narrow subject of tobacco ingredients is all that is protected under the Federal Labeling Act. And that's what we would agree should be protected. However, the documents in question concern health memorandum, concerns how this health information is transmitted to government authorities, and it concerns how this health information is marketed in its advertising campaigns. The trial judge found only the potential for future injury. He did not find the requisite serious economic harm, nor did he find the clearly defined harm, which is required.
What are you really interested in? Are you interested in publishing publishing the information you've discovered, or are you interested in using it in other cases?
Your Honor, we're interested in using our information to evoke information from future potential plaintiffs or from witnesses that might be out there. We want to exchange that information with other plaintiffs in order to further our own case. There are 50 other actions pending presently.
In this district, in the District of Ames?
No, all throughout the country, Your Honor.
Have you sought multi-district consolidation?
No, Your Honor, we have not. Or at least the record does not point out that we have.
Well, wouldn't that be...
So I guess that's an open question.
Wouldn't that be a way for you to share the information with other plaintiffs?
Yes, Your Honor, it would be. However, the distinct nature of each injury in these particular cases is so unique to the given case, and as my co-counsel has pointed out, the different stages in which people started smoking make each case so distinct that multi-district litigation might not be the appropriate remedy here. At least Judge Rice saw for the immediate future that the dissemination of materials would greatly aid not only this petitioner, but 50 others. It would further the purposes of Federal Civil Procedure 1, which is the speedy, just, and inexpensive determination of all the actions.
Would it really help the First Amendment on balance? Because obviously, if protective orders aren't available here or subject to these discretionary judgments giving great weight to the interest in disclosure, then in the future, companies in this position won't keep this kind of record. It becomes poison to have it in your files. So there'll be less research, less...
Well, with all due respect, Your Honor, that's probably an unfortunate truth. However, those incentives exist even now. I mean, all we're talking about is dissemination to the public, but if those documents, as you suggest, exist, then the cigarette defendants here might already be held liable, and there's enough incentive for them to destroy such documents already. But I think it's important that this Court understand the First Amendment rights which Judge Rice took as under the discretion granted to him by Seattle Times into account.
Do you think the Seattle Times really is good law?
Absolutely, Your Honor. The justices that wrote that opinion have my full support.
Some of them
Your Honor,
know that.
excuse me for the levity.
There was a concurrence, wasn't there?
Excuse me?
There was a concurrence in Seattle Times.
Yes, by Justices Brennan and Marshall.
And to what extent did it differ from the majority?
It differed in that I think that Brennan, the concurrence, wished to limit Seattle Times more to the facts of that specific case. However, we have no problem with reading Seattle Times broadly, since Seattle Times grants the trial court the discretion to weigh competing needs and interests. Respondents tonight are going to get up here and urge this court to look at their interests only. But Seattle Times demands more than that. Even the majority says weigh the competing needs and interests in all protective order litigations. Here, the trial court found convincing.
Something vague. I must say, in Canada, there's something vaguely unappealing about the interest you assert, because you've sued these people and you forced them to disgorge documents, and now you want to flag the documents around the media in order to make the cigarette companies embarrass them. You want to pool it with a bunch of other plaintiffs' cases so you can present some overwhelming phalanx of litigation against the companies. Why should that be given great weight by a judge?
Well, that is exactly what the respondents are saying, Your Honor. However, in the trial court, when both of us had our chance to put forward those arguments, we put forward arguments on the other side, that efficiency would result, that less expense would result. And Judge Rice, in the discretion granted to him by Seattle Times, found the petitioner's arguments more persuasive. We're merely asking you tonight that Judge Rice, in doing that balance, not be prohibited, as the Court of Appeals has done, from considering the First Amendment in that balancing test. The First Amendment rights of meaningful access to courts recognized by Seattle Times and further through NAACP versus Button case, in addition to the rights of association and petition under that line of cases, and also the First Amendment rights of dissemination itself, are all furthered by a protective order in this case. Here, we can get outside help, we can share costs, and we can share materials. There's a very real chance if we have nothing to offer other cigarette plaintiffs, we will get nothing in return. That doctrine in the Upjohn case persuaded that court that dissemination was necessary to further the widespread goals of the discovery system.
It helps particularly in contingent fee cases, I suppose. I trust that you have this one on a contingent.
Your Honor, we're only the appellate litigants here.
Oh, you didn't try it on the trial court?
No, they handed us over because we're specialists.
Why? Why is it that an appellate counsel is never the one that tried the case?
That's what I say to you.
He can always hide behind the record and so forth.
But we don't share the
That's
fee.
an unfair question, counsel. Go ahead.
I'd just like to conclude with this, Your Honors. I have no doubt that respondents are about to come up here in a few minutes and go through their interests one by one. But they've already had a chance to do that in the trial court, and they came up short. Seattle Times demands the trial court weigh the interests and look not at just the respondent's interests. Respondents do have legitimate interests, yet the trial court's required to balance them. We ask tonight that the trial court be allowed to include the First Amendment in that balance and not, as the Court of Appeals would have it, ban the First Amendment from the protective order landscape. Thank you very much.
Mr. Acker, we'll hear from you. The calendar is certainly heavy when we're holding night court. I've noticed that everybody says good evening, so just like trial court in your former city, Judge Kearse.
Well, good evening, Mr. Chief Justice. And may it please the court. My name is Stephen Acker, and along with Richard Zabel, I represent the respondents SP Kearse and Higginson Corporation in this lawsuit. I will address the question of federal preemption here. Mr. Zabel will then take up the issues relating to the motion for protective order. The question before this court is whether the state of Ames may accomplish indirectly, through its tort law, what it is prohibited from doing directly under the Cigarette Labeling and Advertising Act. Now, the Cigarette Labeling and Advertising Act provides a recourse to every smoker in this country by requiring cigarette manufacturers to provide on every package of cigarettes sold and in every promotional advertisement for that product a federally specified warning stating that cigarette smoking is hazardous to health. The Act goes on then to ensure the exclusivity of federal authority in the field by expressly preempting states from requiring any other health warning. That is the social policy embodied in the Act. Consumer education and exclusive federal authority in the field. Now, petitioner, whose decedent was confronted with the federal warnings for 17 years and continued to smoke, cannot now disrupt that federal scheme by recourse to Ames state law, which sets its own warning standards and which prescribes a vastly different social policy on the question of smoking and health. I will demonstrate.
That's a pretty good argument, but doesn't the Silkwood case sink that argument? Wasn't that really a stronger case for preemption?
In the Silkwood case, Your Honor? Before the court in the Silkwood case, first of all, it's just simply the question of punitive damages. What the court did there is look back to the Pacific Gas and Electric case I
mean, you have far more federal regulation of nuclear reactor safety than you do federal regulation of the cigarette industry, and yet the court said if a jury wants to award punitive damages because they don't think Kerr-McGee is safe enough, even though it's in compliance with federal law, fine, they can do that.
Well, Your Honor, first of all, the determination in Silkwood, like the determination in this case, hinges on the legislative history of the federal act. Now, it's true that there's a great federal interest in the controlling the nuclear energy. However, what this court found in the Silkwood case was that Congress had had expressly indicated its intention to preserve liability claims, including punitive damages. In this case, what we need to do is look at the legislative intent behind the Federal Labeling Act and discover what lies there. I think we find a very different intent.
Why wouldn't Congress have said that it intended to bar common law tort claims if that's really what it intended, instead of saying that it intended to provide a comprehensive program to deal with advertising?
Well, Your Honor, first of all, it's Congress didn't expressly preempt common law claims. It didn't expressly provide a savings clause. So again, the question comes to what to make of the legislative silence on the issue. It's not although the statute goes to advertising and labeling, the purpose of the Act is in consumer education. In fact, the 1984 amendment to the Act is entitled the Consumer Education and Smoking Act. And when we look at the nature of the subject matter being regulated, which is a luxury consumer good, which is voluntarily consumed, it's not surprising, I don't think at all, that Congress would believe that the way to regulate this, unlike nuclear energy, for example, is to say, consumers, here's the information, now you make your choice.
Well, I assume you're familiar with studies about injury to those who have passively inhaled cigarette smoke. You think Congress intended to preempt those plaintiffs from bringing common law torts claims?
Well, Your Honor,
what good would a warning do to someone who inhales smoke simply because they're in the presence of a smoker?
It wouldn't do any good at all, except for that maybe they could leave the room.
Well, would you concede that those plaintiffs would get to sue for?
Yes, Your Honor. I don't believe that the.
All right. Then what about
Congress...
what about somebody who is addicted and cannot change his or her habits on the basis of the warning?
Well, there you're talking.
Why aren't those two similar situations?
Well, because in one case, Your Honor, we're talking about side stream smoke. In the other case, we're talking about a consumer going out and purchasing the package of cigarettes and reading the warning. Now, the addiction issue in this case was before Congress in 1966, as in the midst of a vast amount of information on the medical issues. It was again before Congress in 1970. It was again before Congress in 1984. Congress believed that smokers who were warned of the very serious health risks associated with their habit, potential health risks associated with their habit, could stop smoking. That fact is indicated in the legislative history. The Surgeon General stood up both in 1964 and in 1969 and expressly stated that he would not use the word addiction to refer to the issue. Congressman time and again stood up and said there is now hope for smokers in this country. In the 1984 Act, there is a warning on packages of cigarettes under the rotational system that says quitting smoking now greatly reduces serious risks to your health. I submit that if Congress had truly believed in the addiction theory that petitioners press, that they wouldn't have wasted their words on that warning.
Congress often wastes words.
No other industry is immune from products liability suits. And why should we presume that a labeling statute passed in order, I think, to aid and protect consumers was meant to create a broad exception for the tobacco industry?
Well, Your Honor, first of all, the cigarette industry is not immune from tort suits. They can be sued just like any other company if they produce a defective or substandard product. But as to the question of an inherently dangerous product when used precisely as intended, I believe that that's an attribute unique to cigarettes on the consumer market, and that it's therefore not surprising that Congress would deal with the issue as it has. Basically, I believe that there are two choices before Congress: either ban cigarettes or count on the free market, modified by a consumer warning, consumer education, to deal with the issue. There doesn't seem to be any in-between point when you're talking about an potentially inherently dangerous substance.
You mean there's no logical in-between point? Is there any requirement that Congress enact something that you think is logical?
No, Your Honor, but I do believe that when you look at the statute, when you look at the legislative history, that the act hangs together in a logical fashion.
It hangs together, though, also, if simply viewed as if you go back to the 66 Act, a primary purpose was simply to get the FTC out of the business of regulating, labeling, and advertising of cigarettes. And then the provision about preemption of states was designed to keep little state FTCs or state legislatures from bringing in the FTC's regulations by the back door. On that reading of the statute, it just has nothing to do with tort suits.
Well, you're exactly correct, Your Honor, in that was the primary concern. It was certainly the impetus behind the 66 Act, the fear that primarily the FTC and then later that states would step in with the scare campaigns, as one congressman called them. But common law tort suits were mentioned by congressmen and senators, both in the hearings and on the floor of the Senate.
Because it was recognized that the warning would interact with a common law defensive assumption of risk in some way. Isn't that the context in which the tort suits are mentioned? That this statute could have an effect on assumption of risk, maybe could even help the tobacco companies, quite regardless of preemption.
Well, it was certainly mentioned in that way, Your Honor. And just to make a brief point before going on and also discussing how it was mentioned in terms of preemption, I think it's important to recognize that point in itself severely undercuts petitioners' core theory in this case, which is, using the language of Silkwood, that it would have been inconceivable for Congress to preempt or to cut out state tort claims. Indeed, from reading the legislative history, it's very clear that Congress recognized the connection between the federal warning and state common law and had no problem at all, didn't even blink in recognizing that there would be a negative impact on those. Now the question is one of interpreting, well, did Congress intend to fine-tune the assumption of risk defense, or did Congress intend to preempt the claims altogether?
Well, if they intended to preempt, why was there any discussion of assumption of risk?
Your Honor, the main discussion of assumption of risk in the memorandum, the Ellenbogen memorandum from HEW in '66, was simply requested by a single congressman asking, we haven't talked about common law here. What's going on? I'm not a lawyer. Can you please inform me? I think that the most plausible interpretation of the references to assumption of risk is one of not really knowing what's coming down the pike in terms of lawsuits. There were only about 7 lawsuits across the country in the 1960s filed against cigarette companies. But making it very clear that that Congress recognized that common law tort suits could have a negative impact on what Congress was attempting to do, and stating their clear intention that the warnings would have an impact on the common law claims. In fact, at the one point at which preemption actually is directly connected up to, explicitly connected up to the common law claims, is in the 1969 hearings, when Representative Watson, who is quoted by petitioners at page 11 of their brief, is discussing the preemption issue. And as petitioners correctly point out, Representative Watson states in those hearings that in his opinion the 1965 Act didn't preempt claims. Representative Watson goes on 3 pages later in the legislative hearing discussing preemption still, and states, and I quote, "If we are to pass their recommendations and state is a hazard," that is in upgrading the warning from may be hazardous to is a hazard, and I continue to quote, "then I can assure you that in all probability would prevent any common law action."
From what state was the congressman?
The congressman was from the state of South Carolina, Your Honor. Senator Moss from the state of Iowa, from the state of Utah, was the leading sponsor of the 1970 amendment. And Senator Moss, who we quote in our brief, stated that he saw, in 2 minutes before, or moments before the passage of the 1970 amendment, on the floor of the Senate, Senator Moss stood up and said, "I think that the tobacco industry, the tobacco state, should be as happy with this bill as the state interests, because this bill is going to provide, I'm not quoting the exact language, but it's in the brief, going to bar common law claims." Representative Moss was from Utah once again, and I think it's important to point that out.
Congressman or senator?
I'm sorry, he was a senator, Your Honor. Now, what I wanted to do was demonstrate 2 points this evening. First, that the Cigarette Labeling and Advertising Act occupies the field of health warnings and therefore preempts Ames law based on duty to warn. And secondly, that all of the Ames laws...
But your opponent really isn't pressing the duty to warn. I mean, it's kind of a backup position for them, just in case they can't prove that Mrs. Phillips was in some sense addicted or unable to stop smoking. So how much do you have to gain by prevailing on this issue?
Well, Your Honor, if petitioners are willing not to press the duty to warn issue, we of course...
Well, they're not willing to concede it, but it doesn't seem to be... What of the plaintiff's case, in your view, would survive if we held that the Federal Act had this preemptive effect?
Well, Your Honor, we strongly believe that the duty to warn claim would go. Now, as you say, that seems to be the weakest of the claims. The reason that we believe it's important to present that issue here is that one of the central policies behind the Act is warning uniformity. We want to ensure that policy of warning uniformity is preserved. But beyond that, our position is that all of petitioners' claims are barred under a conflict preemption analysis. That is, all of petitioners' claims conflict with the purpose...
Everything is barred?
Yes, Your Honor.
What if they make a claim about deceptive advertising? What if cigarette companies had big ads which said, ignore that nonsense on the label that Congress requires us to put there, it's phony, there's no hazards to smoking? Is it your view that she would have no cause of action?
That's correct, Your Honor. The FTC...
That's preempted also.
That's correct, Your Honor. The Federal Trade Commission would obviously have jurisdiction over that, and I'm sure would exercise that jurisdiction hastily. But Section 1334B of the Act states, Section 1334A of the Act just discusses the statement on the label itself. Section 1334B of the Act goes on to discuss the advertising issue and states, no requirement or prohibition based on smoking and health shall be imposed under state law with respect to the advertising or promotion of any cigarette packages, cigarettes, the packages of which are labeled in conformity with the provisions of this chapter. So long as the Federal Act is complied with as respondents...
They could say anything they're advertising.
That's correct, Your Honor, with fear only of federal enforcement. The strict liability claims are really a paradigm of what this case is about. What the state of Ames is doing with its strict liability law is carrying out a risk-utility analysis, analyzing the social utility of this product of cigarettes. Yet this is precisely the same risk-utility analysis undertaken by Congress in the Cigarette Labeling and Advertising Act. That Ames will arrive at a vastly different conclusion, at least on the utility side of the balance, is clear, I think, from the district court's opinion at page 32, footnote 1.
What if the state of Ames attempted to outlaw the sale of cigarettes in it? Would that be I mean, that might raise problems on the interstate commerce. Would that be preempted by this Federal Labeling Act?
Well, Commerce Clause questions aside, Your Honor, our position is yes. The purpose of the Act, and it's if I may just answer the question.
Finish the question.
The purpose of the act is to preserve consumer-free choice. That's stated throughout the legislative history. Because a prohibition would directly fly in the face of that legislative intent, it too would be preempted. Thank you.
Thank you, Mr. Acker. Mr. Zabel, we'll hear from you.
Mr. Chief Justice, and may it please the Court. My name is Richard Zabel, and I represent the respondents Kearse and Higginson corporations in this action. This case presents the question of whether there are limits to a litigant's use of discovery materials. I will demonstrate that there are, and that in analyzing a motion for a Rule 26C protective order, such as the one in this case, a trial court must not consider the First Amendment. One thing is clear from this Court's decision in Seattle Times v. Reinhart, and that is the last sentence that Justice Posner pointed out. It states that the First Amendment is not violated by a protective order that is entered on a showing of good cause as required by Rule 26C, is limited to the context of pretrial civil discovery, and does not restrict the dissemination of the information if gained from other sources. The Seattle Times Court thus resolved an apparent conflict between Rule 26C and the First Amendment, and settled the standard under which protective orders can be granted. That standard is good cause. The litigant does not have any heavier burden of satisfying any First Amendment standard. I will show first that petitioner has no First Amendment rights to disseminate these discovery materials to other litigants or to the public. Secondly,
Suppose the case were consolidated for pretrial proceedings.
consolidated with the other 50 cases.
With the
Your
other
Honor.
50 cases that were pending, which sometimes happens. Wouldn't they all have the right to share the fruits of discovery?
Your Honor, under our theory, even if the case were not consolidated, all outside litigants, these 50 other litigants, have to do is move to modify the protective order. The standard for that is only to show that they are similarly situated, not
And
that they have.
you would not oppose such a motion?
Your Honor, whether we would oppose the motion or not may have to do with whether the other litigants are similarly situated. But it's
Well,
commonplace.
if they showed they were similarly situated, then are you saying that you would not oppose the motion?
Your Honor, that would depend on other factors, the nature of the suit. Of course, I can't comment on what those suits would entail. But the important point that you're bringing up is that under our theory, where the First Amendment is not taken into account, other litigants are not barred from this information. They move to modify the protective order, and if they are similarly situated, they are granted the information. Second,
These documents are in the physical possession now of the plaintiffs?
yes, they are in the possession of, some of the documents are in the possession of petitioner. They also are moving to disseminate information that they may get in the future, Your Honor.
Should the court give different degrees of protection to different categories of documents? I notice your motion says that you'll be exposed to humiliation and annoyance, and I presume there's some trade secrets that you want protected as well. Should the court try to fine-tune a protective order to give different degrees of protection to the different categories?
Your Honor, the different degrees of protection that would be required, that would be a problem under petitioner's theory, where First Amendment would have to be taken account and different items of information would have different constitutional weight under the First Amendment. Under our theory, there is only one standard, and that is the same theory that the Seattle Times Court laid out, and that standard is good cause. Any material we can show good cause to, for which we should be granted a protective order should be protected.
And you think that the likelihood of annoyance is equally good cause with protection of trade secrets?
Well, Your Honor,
I think those two equally show good cause?
Your Honor, I think they both meet the good cause standard. I think the problem that you're getting at that would come under petitioner's theory is that a trial court, in a situation where trade secrets are at issue, would be presented with a situation where it would be forced to weigh the First Amendment against the Fifth Amendment. The Fifth Amendment, because the disclosure of trade secrets could constitute a taking. That is exactly why the Seattle court examined Rule 26C and carved out a narrow context in which protective orders could be issued under the good cause standard, and where the First Amendment would not have to be weighed, and thereby hindering the trial court's discretion.
Well, you're not making a taking argument with respect to any documents that don't contain trade secrets, are you?
No, Your Honor, we're not making a takings argument as to those documents. We do not even need to make a takings argument as to any of the information, because we've satisfied the district court that we have shown good cause to the district court. The district court, indeed, despite petitioner's claims, did not have any discretion in this case. It said, absent the necessity of having to consider the First Amendment, it would have granted a protective order in this case because good cause had been shown. We do not need to show that there's been a taking. We do not need to show that there's been a violation of privacy rights. All we have to do is meet the good cause standard. We satisfied the district court as to that standard, and we satisfied a unanimous circuit court as to that standard. Petitioners have no First Amendment right to disseminate any of this information because in the context of discovery, the broad powers they have been granted to gain this information, to gather this information, to in effect, the broad powers that litigants are granted to invade each other's privacy, those are a form of legislative grace granted under a statute, under the rules of discovery, and they are granted so that litigants may prepare for suit. That is the purpose of the rules of discovery. It is not unlike other...
You didn't produce these pursuant to an order, though, did you?
Excuse me?
You didn't produce these documents in response to an order.
No, Your Honor.
We exchanged them voluntarily.
We produced them voluntarily under an oral agreement, an oral confidentiality agreement, and we would still be producing them today had that agreement not been renounced or said to be potentially renounced by petitioners. Nevertheless, it's clear from the discovery rules that much of this information, if not all of it, would have been judicially compelled to be produced under the discovery rules. And
why didn't you just refuse and make them apply for an order of discovery if they're so embarrassing and touchy and so on?
Well, Your Honor,
trust to their good faith.
I don't think that respondents' good faith in voluntarily coming to an agreement, the lawyers in this case coming to an agreement as to the exchange of discovery, should cut against the respondents. The Manual for Complex Litigation says it's ideal for litigants to arrange discovery among themselves and not drag the court into it. Of course, we could have forced them to go to the court and make us give up documents. However, that would have seemed to just proliferate disputes rather than to expedite discovery in this case, which was happening under the oral agreement. As I said then,
Can you sue them for breach of contract?
Whether we can sue them for breach of contract is a separate issue, Your Honor. The issue that we are concerned about is that the respondents not be bankrupted by the disclosure of their trade secrets to competitors and to the rest of the public, and not be subject to humiliation, embarrassment, and annoyance, as Rule 26C states, which may even prevent them from getting a fair trial should this case go to trial in the future. The reasons that the standard for issuing protective orders is good cause and not First Amendment scrutiny is that any injection of a First Amendment issue would undercut the substantial government interest that this court in Seattle Times recognized underlie the discovery process. The court recognized two substantial government interests. One, in protecting the privacy of litigants who are involved in the discovery process. And the second interest was in allowing trial courts the discretion, the ability to manage efficiently the discovery process. In this case, it is clear that the information that we seek to protect stands at the heart of our entrepreneurial enterprises. That is, it is confidential information that constitutes private information. And this court recognized in Seattle Times that privacy is the rationale for Rule 26C, the protection of privacy. The fact that the disclosure of trade secrets and other information would affect a taking only serves to show how extreme petitioner's theory that the First Amendment must be weighed in each protective order motion, how extreme a burden that would put on trial courts attempting to issue protective orders and having to choose between the First and Fifth Amendment. Now, the second substantial government interest was in allowing trial courts to efficiently manage the discovery process. The injection of a First Amendment issue into every protective order motion would force trial courts to protract the discovery process as they made the necessary burdensome evidentiary findings to decide constitutional questions. Protective order motions would be constitutionalized, and a trial court would have to weigh the evidence as to factors such as public interest in the documents, other factors that bear on the First Amendment.
Does it have to weigh it with respect to each document or category of document, or can it simply weigh the public interest in the subject matter?
Well, Your Honor, that points out, I think, what is another inescapable problem with petitioner's theory. That is, normally, a court has the discretion to issue an umbrella protective order, a broad protective order, as to categories of information. However, under petitioner's theory, the trial court would have to do a document-by-document approach and would virtually be held hostage to years of discovery, because each document would have a different constitutional weight as to the public interest in that document.
Did you make this argument to the district court?
Excuse me?
Did you make this argument to the district court, which probably would have been more receptive to it than we, who would not have to do a document-by-document?
Well, Your Honor, I was not there to make this argument to the district court. However, I can tell you that the district court on page 35, in its opinion, recognized that broad discovery orders, categorical or umbrella protective orders, those do expedite discovery. It recognized that fact and then said, absent the necessity to consider the First Amendment, since it had found good cause, it seems that it would have granted the protective order, and it recognized that the most efficient type of protective order in this case would have been, as respondents did point out in the district court, a broad protective order. The second problem then with injecting a constitutional question into protective order motions is that it would create a question of law as to what was formerly a discretionary decision by trial courts to grant protective orders. That would lead to an incredible amount of interlocutory appeals to both the circuit courts and maybe to this court.
Well, what is the basis for an interlocutory appeal here? Maybe the Court of Appeals didn't have jurisdiction.
In this case, Your Honor,
Yeah.
in this case, the Court of Appeals said that under 1292B, an interlocutory appeal can be granted if the district court certifies it for appeal to the circuit court and the circuit court accepts that certification. That's what happened in this case. The circuit court went on to point out, however, that the appeal also would have come up to it, had it not been done in that manner, would have come up on mandamus because the district court had committed a clear error of law. That clear error of law was to inject the First Amendment into this inquiry where the good cause standard should have been the standard.
You mean you can get mandamus every time the district court clearly makes a mistake of law?
Well, Your Honor, I wouldn't presume to say that. A mandamus is an extraordinary writ, and it's not that often granted. However, it has been granted on protective order motions with this type of fact pattern, and the circuit court said that it would have granted a writ of mandamus in this case. And I think that that's what petitioner's theory, which injects a First Amendment, a constitutional question into each protective order motion, would lead to.
Why is a constitutional error more likely to be clear than a non-constitutional error?
Not that it would be clear, Your Honor, necessarily, but that it would...
Your conception of mandamus is that a discovery order or anything, anytime the judge makes a clear error, the Court of Appeals can jump in and reverse it.
No, Your Honor, we do not claim that writs of mandamus would be running rampant.
I mean, suppose a judge made a clear error in excluding evidence. Could the lawyer say, hey, wait a minute, Judge, I'm going to get a mandamus to make you reverse that one?
Well, it is up to the court, of course, to grant a writ of mandamus, Your Honor. And I think that even if writs of mandamus were not being granted all the time, which they shouldn't be and probably wouldn't be, the fact remains that injecting the First Amendment into protective order motions creates a question of constitutional law. And that would be coming up on appeal. No matter what level of First Amendment scrutiny you would inject into protective order motions, it's still a constitutional question and an important one and would lead to interlocutory appeals. This case demonstrates that, and so does Seattle Times.
But if the judge had granted this, why couldn't your opponents say, look, this judge made a clear clear error in giving weight under 26C to embarrassment that an industry might feel when it is discovered that it is killing people. Why couldn't that be argued as clear error?
It could not be argued as a clear error of law, Your Honor. It would be the good cause standard is discretionary, and it would have to go up to the Court of Appeals on an abuse of discretion, as an abuse of discretion. The other claim for a First Amendment right to disseminate that petitioners have asserted is that there's great public interest in this information. The magnitude of the public interest in the information does not create a First Amendment right of access for the public to discovery materials, nor does it create a First Amendment right to disseminate the materials to the public. The public interest is triggered, the First Amendment right of public access is triggered by evidence. When it goes into court and becomes part of the evidentiary record, the public documents of the court, then the First Amendment right is triggered and the public has access to the information. Evidence is the touchstone of a First Amendment right. The public civil discovery has never been open historically to the public and should not be made open under petitioner's theory now to the public. The other problems with petitioner's theory as to injecting a First Amendment interest into the discovery process is that the First Amendment interests, and it's as is evident, I think, in this case, are not necessarily beneficial to the petitioner, to the client. They're interests that the lawyer has in material that he has become aware of through the discovery process by allowing the First Amendment issue to be raised to allow the dissemination of discovery materials would create a situation where lawyers who had come upon valuable information could use the discovery process to create, as the circuit court noted in its footnote in this case, a commercial asset for themselves. That is information.
But you can't prevent that, because unless we threw out your entire case, you presumably will be forced by this information to settle under threat of having it put into trial and bankrupting the industry, won't it?
I'm not sure.
I mean, you say it's dynamite, it's disaster for you if this comes out. But of course, it will be admissible, most of it, at trial.
It's not clear, Your Honor, that this case will go to trial, and we certainly...
Well, if we don't knock out every claim that the plaintiffs have, then there will be triable issues.
There will be triable issues, Your Honor, and...
There'll be a motion for summary judgment.
Yes, Your Honor, there will be,
and then in response to that, all this dynamite will come in, and it'll be part of a public record, and it'll be widely broadcast.
Your Honor,
so this is just a delaying action for you, isn't it?
Well, Your Honor,
a few months.
No, Your Honor, I don't think it's a delaying action. It's not clear what information will come out at a trial, whether there is a trial. The important point, though, that your question points up is that whereas there would be irreparable harm done to the respondents in this case, should the information from discovery be revealed, it is clear that it's only a delay for the petitioners and outside litigants who will have access to the information once it becomes part of the trial record. In summary, then, what is at stake here, it seems clearly to be the integrity of the discovery process. And more importantly, at stake is whether this court will allow litigants to be stripped of their privacy by the limitless use of discovery materials. We respectfully ask this court to affirm the judgment of the Circuit Court of Ames in all respects.
Thank you, Mr. Zabel. Mr. Engelmayer and Mr. Grisanti, do you have rebuttal? You have, I think, 4 minutes for it.
We will waive our rebuttal time.
You will waive it. Well, the case is under submission, and the court will do its best to resolve it.
All rise.
everyone please sit down? The judges are ready. We'd also like to remind everyone that there will be a reception immediately following the judge's decision in the Ropes Gray Room in Pound.
All rise.
Well, now comes the hour of reckoning, I suppose. What I've asked Judge Posner and Judge Kearse to do is to make initially some general comments about the argument, and then eventually we shall do our best to name the winners of the best brief, if you will, and the best oral argument and the winning team. These are always excruciating choices, but as I think all of you can appreciate after the argument tonight. Judge Posner, would you want to make some general comments?
Okay, thank you, Justice Breyer. I will make just 2 points about the presentation of the case. The first has to do with the use of precedent in the briefs. As the case was created, skillfully created, I might add, there were 2 cases that had a commanding significance, one favoring the plaintiffs, the petitioners, one the respondents, the defendants. The Silkwood case seemed to be a very powerful precedent supporting the petitioner's position with regard to preemption. And the Seattle Times case seemed an equally powerful case supporting the respondent's position with regard to the protective order. But in neither of the briefs what were these cases really drawn to the court's attention in the most forceful way. And we thought, all of us, that the briefs would have been more effective if focused on these cases respectively. Telling the judges, telling us, that is, exactly what these cases were about and what the court held, rather than simply referring to them from time to time and not sufficiently emphasizing their central importance. So that's just a minor criticism. A second point, not really a criticism at all, but a comment on a curious feature of the case. Although it's a very skillfully created case and very interesting and well balanced on the merits so that each side had a good issue and a weak issue, the case has buried in it some jurisdictional problems which made it seem, to some of us at least, a somewhat premature case, actually. It's not at all clear, for example, that the preemption issue is properly brought to the Court of Appeals under Section 1292B. There's a small technical reason for this and a larger reason. The small technical reason is that the way in which the record is written, it is implied, although not stated, that the only certification of the issue was by the district court, whereas the rule, of course, requires that the Court of Appeals be asked within 10 days to certify the issue for review, and if it doesn't, then the fact the district court certified it is of no moment. The larger issue is whether this is really the sort of case that the framers of 1292B thought would be brought up to the Court of Appeals. The issue of preemption is a very difficult issue, very important issue, but not clearly dispositive of this case. And moreover, it's not clear that the issue can be properly evaluated in advance of trial, because judges interested in deciding the case on as narrow a basis as possible would like to know what use would be made of the warning issue at trial. Would the federally mandated warning be disparaged by the plaintiff's counsel? What use would be made of it by the defendant? So the issue might be a good deal more ripe after a trial, and that would be a powerful reason for not certifying it under 1292B. There's also a question about the protective order's appealability to the Court of Appeals. It doesn't fit 1292B at all. It fits mandamus only in the sense that everything fits mandamus. That's a catch-all. Discovery orders are very rarely subject to interlocutory appeal. The standard remedy, if you're really upset by a discovery order and want to appeal it immediately, is to refuse to comply and be held in contempt, criminal contempt, and be an appeal from that, which you can do. The issue is made murky here by the fact that the respondents had turned over some documents as to which contempt would no longer be a remedy, but not others. Again, I think a real court would be delighted to be able to duck the issue by refusing to hear it at this time. Although courts have disagreed, it really seems a classic case for use of the collateral order doctrine, another route of appeal, but not involved in the problem. Having made these points about the case and about the briefs, let me say that I thought that the case is an excellent case, very cleverly created, very interesting to us, and very challenging and very well balanced and well adapted to an argument by 4 people. And I thought the briefs were excellent and the arguments were excellent, and so that I think both the people who created the case and the people who have presented the arguments should certainly be congratulated.
Judge Kearse.
Thank you. I'd like to direct my comments principally toward the oral argument, which we all found to be of very, very high quality on the part of all 4 of the oralists. I thought that all the oralists did a very good job of being responsive to the questions of the court. One of the things that we find sometimes in real court is that the parties are not terribly responsive, and especially there, unlike here, we really want to know the answers to our questions. So to the extent that you can continue to be responsive to the questions, you will advance your cause. We threw you a few curveballs on the jurisdictional questions, simply because they were there, and I think that by and large you did as good a job as you could with those. I think it's also important that you be able to hit a curveball, because you'll get a few of those in real court also, whether it's because the judge is thinking of a different case or because there's something in the case that you haven't foreseen. I was also impressed with the ability of each of you to weave into the main stream of your argument the answers to the questions that we were throwing at you, because sometimes we would anticipate something that perhaps you had intended not to reach until later in your argument. And one of the most frustrating things for a judge who wants to know the answer to a question is to hear, "I'll get to that, Judge. I'll get to that later in my argument." We have perhaps a childlike desire to know immediately. We ask a question, we want to know the answer to it. I'd finally like to say that I think that in comparison with the lawyers that we hear every day, you are all better than about 95% of them. Of course, I will also point out that you'll probably never again be as well prepared as you were tonight.
Thank you. Well, first of all, I would like to express appreciation on the part of the panel here to Professor Charles Nesson, who I understand supervised the case, suggested it, and came up with what we feel is a good one, and to Renee Landers for her preparation of the record. I almost called her Ann, but this is a big job to do, and I think it was a job that was well done and deserves an expression of appreciation. And then to Michael Feely, who is here and has supervised it generally. It's a lot of work, I know it is, and I think they are to be commended for it. Well, so far as my general comments are concerned, they are very general. I hope this is a great day for you, the four of you, and the others on the brief, and let's not forget them. I say that because I was on the brief 100 years ago. But, and I hope it's a happy day, however it comes out. I think you're especially privileged to have participated in the final argument of an Ames competition that really goes over your entire law school curriculum. I'm sure you look back on this, not only tonight, but on the experience. And if you are not chosen as the winner, I hope you will realize it isn't the end of the world. I echo what Judge Kearse said, that the performance tonight, I think, ranks high among the practice of appellate practitioners in the courts, the federal courts of this country. I wish that every case in the court in which I'm privileged to sit were as well argued as this one was. I think initially when we look at these briefs, we are pleased that we do not have to decide the case on the merits. They are so evenly balanced, and yet after we hear the argument, we wish we could decide it on the merits. And tonight was no different than many others. Someone has to lose, and that's the nature of litigation. It's the nature of the profession you have chosen to follow. And so you have to anticipate as you get out into practice that you're going to lose some, you're going to win some, you'll win some you don't deserve to win, and you'll lose some that you know you should have won. And but I think I can say without any hesitation that you will succeed, the four of you and the rest of you on the briefs. And the future lies bright ahead of you. I suspect you will not be bored with an actual case as much as you probably are with this one. The way you labored on it and the way I noticed your specially assigned work tables up in Langdale Library this afternoon. I was tempted to put those books away myself. But, just a couple of comments, and I think the judges here will agree with me on it. Don't ever be concerned if your carefully prepared oral argument goes down the drain due to questions that the court advances. As Judge Kearse stated, the court wants an answer to its question, and it wants it right now. And many times lawyers wonder about a question that is posed that is not on all fours with the one under consideration. And the reason, of course, is that the court is looking ahead to the next case and to the ramifications of the decision in this one. And it's always disturbing when counsel said, well, that isn't this case. And then to mimic my good friend who sits next to me, Justice White, he'll say, yes, yes, but answer my question, counsel, answer my question. And so there's a bit of a tug of war. So I do say I generally answer the questions put to you specifically and without conditions. And I think this was done generally tonight. Know when to sit down. You know, some lawyers, if we give them 30 minutes, are through in 10 minutes and they start all over again, and then they start all over a third time just to take up that 30 minutes. Former dean of this law school, Erwin Griswold, is in this respect one who never errs. He is thoroughly prepared as he argues before our court. He never exceeds the time limit, and he never repeats. And if you can ever see him argue sometime, I recommend and commend it to you. I think also you should remember that in a court with as many members as our court has, 9 of them sitting up there like a long line of owls looking down at poor solitary counsel, sometimes the questions amount to arguments among the justices themselves. It's like testifying before a Senate committee with that horseshoe table. It took me a little while when I went through the confirmation process to realize that some of the questions, although ostensibly directed to me, were really directed at their counterparts across the table. And I think to a lesser degree that is true in a 9-judge panel. Know your facts and know your record, and this is particularly true if you are not trial counsel. Don't hide behind the fact that somebody else tried the case. I think also it's well to remember that a decided case is not Judge Zilch's case. If he wrote the opinion, it's the court case. He may have authored it, but it is a court decision and not the author's decision. I thought it was interesting. I don't know whether any of you have been watching Fred Friendly's Managing Our Miracle series on PBS on Tuesday evenings at 10 o'clock. But the last program was on this very subject. I thought it was a good one. And Professor Nusson was holding forth. He started off very nervous-like, holding a cigarette, and went in and confronted somebody and said, I'm going to marry your daughter, but I have, and we took off from there, they took off from there. So that these are pertinent and live and pregnant problems, so to speak, that are current today. I think it is a fact. I saw it in a reputable medical journal this week that of those persons who will die this year from cancer, about 30%, or 145,000 people, have their cancer linked to cigarette smoking. I well remember when I was on the staff of Mayo's and the first inkling of this problem broke. The chief of the biomedical division came in storming into my office one day and he said, the AMA is nuts. Well, I said, Joe, what's the matter? And he said, the statistics don't prove their case. Well, he was a chain smoker, and I wasn't surprised that he felt that way. But there are today those who feel that, as certainly some of the cigarette companies profess to feel, that smoking and cancer has not or have not proved to be linked. Well, I've said before here, I'm sure, that I think it was Justice Jackson who said that if the day comes when you make an oral argument and you're not excited by it, the adrenaline isn't running, don't make it. It's one of the great days in your life, and that's not only true here, it's true in any argument, I think, before any court. And one day you'll be privileged to argue before these 2 very splendid appellate judges. and I think it'll be an exhilarating time for you to have that experience. So compliments are due all around. I hope that you have learned something by this experience. I know that we have. And tomorrow, I guess all of us will go back to our jobs where the cases are a little easier to decide. Well, having made you wait all that time, I think the first thing we have to announce is which side's briefs are the better. And Judge Posner, would you take that one on?
Yeah, we thought the briefs were of extremely similar quality, and that is not said simply out of politeness, but was in fact the reaction of all three of us. Thought they were excellent briefs, and as I say, virtually indistinguishable in quality. But forced to make a choice, and recognizing the difficulty of it, we decided that the briefs of the respondents, of the 6 unknown named agents team, their brief was marginally superior, and so that's our decision on that aspect of it.
The next is the best oralist. Judge Kearse?
Again, we had a difficult decision to make because we thought that all 4 of the oralists were very, very good, so that the one that we have named best was not best by a wide margin. On the other hand, he can brag that he was best of a good lot, and that is Richard Zabel.
Well, that leaves us the winning team, and I suppose those 2 awards indicate that with difficulty, and I say this with sincerity, with difficulty, we have decided that the respondents should be named the winning team for this year.